Our next distinguished speaker is Branden Butler. Branden Butler is an Assistant Deputy Director, Department of Fair Employment and Housing. Before joining DFEH, Branden was the Senior Attorney of the Fair Housing Center of the Legal Aid of San Diego, Inc. for 9 years. Branden has litigated fair housing cases, led specific campaigns addressing discrimination against persons with mental health disabilities and source of income discrimination. Branden is a frequent speaker and educator. Branden was the president of the San Diego Regional Alliance for Fair Housing from 2016 to 2019. He began his career as a housing advocate at Communities Actively Living Independent Free, a disability rights organization in downtown Los Angeles, where he advocated for housing rights for persons with disabilities. Branden is a native Californian, graduated cum laude from Thomas Jefferson School of Law, and earned his BA graduating magna cum laude from California State University, Chico. Please join me in welcoming Branden Butler. Mr. Butler, the floor is yours.
Well, thank you, everyone. It's a pleasure to be here this morning with so many friends and folks and stakeholders of the Department of Fair Employment and Housing. So it's always a pleasure to be invited to speak on the Employment Awareness Month for the National Disability Awareness, as well as to again always connect with our stakeholders on the impact of civil rights for persons with disabilities and our work at DFEH. And of course, I come speak to you from remote a Zoom situation here in my COVID bunker as we get through this pandemic. And it really is an interesting time for the disability community in terms of employment opportunities and work itself as we go through this pandemic. And I want to talk a little bit about some of the doors that may be opening, but I also want to talk about some of the struggles we face with disability discrimination in the employment context, and how perhaps the pandemic is opening a window to more opportunities for employment for persons with disabilities and meeting this challenge. So, so I'll start with that. I mean, but first, and I want to thank, Bobby, especially for inviting the department and helping set this up so well. But to start out, for folks who may not be totally aware of DFEH and what we do and who we are your civil rights organization. We are California's civil rights organization. We are a law enforcement body that enforces the civil rights laws for all Californians. So we work for you. We're here for you. And as you'll find out, a great majority of our work involves cases involving persons with disabilities facing discrimination. So as a little bit of the outset, that's who we are. And our mission is broadly to protect everyone in California from unlawful discrimination. Today I'm going to talk about employment, but we also cover housing. We also cover public accommodations, right? So we essentially enforce the ADA equivalent in California here in businesses, et cetera. And we also cover acts of hate violence, which have unfortunately been upticking during the COVID pandemic against our Asian community partners, as well as we also cover the human trafficking jurisdiction in terms of the civil offenses and representing the victims of human trafficking on the civil side. So we have a broad mission, but primarily how you may know us is that the Department of Fair Employment and Housing is the place where folks will file complaints for employment discrimination. So we have, a great many investigators who do a lot of hard work in investigating these cases, and cases that don't resolve via settlement, we enforce the law in state court. And that's what I mean by a law enforcement body, that we will file claims in court to enforce the civil rights laws of California. So we start there with just a little bit about DFEH. And in terms of a little bit about me and my connection to the disability community and why I think this is the ongoing one of the primary missions of civil rights is enforcing disability civil rights laws. Is I started out with my father, who was a high school teacher of students with developmental disabilities for over 30 years. I spent a great deal of my time, in the classroom as an aide and working with students for many years, and seeing students go to college, become independent, and obtain employment. But that wasn't always easy. And there certainly was a great deal of discrimination that folks and students of my father's had to endure. I went on to work as the independent living skills specialist for the ARC of Butte County, where again, I was working with adults with developmental disabilities who were seeking employment and living independently, and seeing the effect and the importance of our civil rights laws to ensure that there could be accommodations be made for folks to become gainfully employed. And then, as Bobby mentioned, my time at Cal Life Independent Living Center under the direction of disability advocate and personal friend Lilibeth Navarro, I also saw the challenge of staying employed when you have a disability, and the many factors around transportation, healthcare, attendant services that are faced with folks with disabilities and with significant disabilities who are working. And as my time as a legal services attorney, many of my cases were representing persons with disabilities, and through that relationship, finding the struggles that they face in terms of being employed or losing employment due to a disability. So I think, for my life, I see the disability community as a home base where I think the civil rights laws are greatly needed to be enforced. And it's also an area where there's a lot to be proud of in terms of where we've gone and where we've come from. And, I think I'll talk a little bit about our Fair Employment and Housing Act, which provides our employment protections for persons with disabilities. But I'll take it a little bit further back to say that, we're here today really through the work around the country and with so many disability rights advocates and allies who were so forceful in pushing through the Americans with Disabilities Act. We celebrated the 30th anniversary this July. And I think it's important to commemorate that this is one of the last bipartisan civil rights movements that really has taken root in our country. And but it wasn't easy, and I know many folks on the line here today could attest to that, including so many of the activism that was required to get it passed. But here we are, 30 years later, with the Americans with Disabilities Act that has provided employment opportunities for so many folks with disabilities. And I always like the quote from, the late President George H. Bush when he signed the Americans with Disabilities Act, saying that I now lift my pen to sign this Americans with Disabilities Act and say, let the shameful wall of exclusion finally come tumbling down. And I think that message is so important because while the wall has come tumbling down in many regards, there still are a great many barriers faced. And we still have a long way to go to achieve that, total inclusion for persons with disabilities in the employment context. And so there's so much to celebrate, and that certainly is true. But also, as we talk about the new opportunities opening because of the pandemic and technology, I do want to mention that, when I was reviewing the Office of Disability Employment Policy and some of the data for 2018 and 2019, I was reviewing the 2018 to 2019 and seeing where there's been changes. We heard so much about the economy in 2018, 2019, but, still across all age groups, the employment ratios for persons with disabilities were much lower than for folks with no disability, right? And that's coming from the Office of Disability Employment Policy. And they also go on to say across all educational attainment groups, the jobless rates for persons with a disability were higher than those for persons without a disability. And when you look at 2018 to 2019 data, when we saw this great employment, economy, so to speak, we really didn't see a lot of change around folks with disabilities being employed. There was a slight decline, but it did not increase greatly. And in fact, in the 2019 data, when we look at the civil rights on the racial side, we saw employment rates for persons with disabilities who are persons of color was much lower than for those who were Caucasian individuals. So we still have, not only the disability complexity, but the broad cross connection of our civil rights laws into the employment context. And then, lastly, another data point I thought was interesting from what the federal government was saying in their surveys, where that persons with this disability were less likely to work in management, professional, and related occupations than those without a disability, based on the data. So we still have some, ways to go, right, when we look at our federal data. And when we look here at the state of California, we just released our 2019 annual report, the Department of Fair Employment and Housing. This is where we list all of our complaints, what did we receive by type, et cetera. And when we looked at the 2019 employment discrimination cases, yet again, the highest level of complaint was for disability-based discrimination, okay, by far. And in fact, disability. So we had a total of employment filings. We had 5,183 cases filed with our office. But often, folks will allege it was disability discrimination. It was another type. So we had a total of 16,000 bases. So when you look at disability discrimination for 2019, there was 2,868 complaints filed for disability-based discrimination. The next highest was that of harassment, which could be on any form of harassment, including disability, which was at 2,325. And then for accommodation-related complaints, which can be, again, multiple, we had 1,221. So disability was, again, large. And then another data point that I also want to share with you is not to get too deep into the employment discrimination law, but when you file a complaint for employment discrimination, you can either file it with DFEH and we'll investigate the case and come to resolution, et cetera, or you can just quote unquote exhaust your administrative remedies and request a right to sue letter from the department. So you still have to file with us, but you'd immediately get a letter to sue, and you can go into court and bring your own case without us. So out of those cases, the quote unquote right to sue letter complaints we get, ones we don't investigate, but folks who are just alleging that they were discriminated against and want a right to sue letter. And so we, out of these complaints for disability discrimination, was the highest again for this separate area, where there was 13,101 complaints for disability discrimination. The next highest was in the 6,000. So you can see again, disability-based discrimination remains a constant. And this was this year, it was 2018, it was 2017. Almost every year in employment, disability-based discrimination is the highest. And there are a lot of reasons for that. But it tells us that there's a lot of reasons, because there may still be much discrimination occurring. And anecdotally, I'll just say in our housing discrimination cases, disability is also the highest. So just saying across the board, the civil rights of persons with disabilities is a major concern. And this is why it's so important to have these events to talk about those rights, to raise awareness. So I just give that not to sober us, but to just let us know that the struggle continues. So much to talk about in success, but we have much to go. So with that backdrop, the Department of Fair Employment and Housing, we enforce the Fair Employment and Housing Act. And the California Fair Employment and Housing Act requires employers of 5 or more employees to provide reasonable accommodations for individuals with a physical or mental disability to apply for jobs and to perform the essential functions of their job unless it would cause an undue hardship. So we are the place where the complaints go for reasonable accommodation. And that's one reason why we have so many complaints, because if an accommodation is denied, it will be seen as, it could be a violation of a civil rights law, and there often are many accommodations required in the job place. And so just, so we're all on the same page, a reasonable accommodation, as we all know in the workplace, could be a lot of different things: changing job duties, providing leave, changing work schedules, relocating to a different work area, providing, assistive technology. So there's a great, many types of reasonable accommodation that are out there. But I think as we talk about the reasonable accommodation in relation to COVID, we're really seeing this issue come up a lot more because of the impact of COVID-19 on persons with disabilities and the need to perhaps have reasonable accommodations to telework, leave of absences, et cetera. But one of the unique factors of the right of reasonable accommodation in California is we have also the idea of the interactive process, right? This separate step where, that there must be an interactive process where an applicant, an employee, or requests reasonable accommodation, the employer must offer to initiate an interactive process when they become aware of the possible need for an accommodation. Oftentimes, this is where many issues are resolved, is in this interactive process, a real effort to try to resolve and find an accommodation that will resolve the issue without an undue financial burden. And so we're proud that we have that in California. But in California, if an employer fails to engage in this timely, good faith interactive process, that in and of itself can be a violation of our FEHA. So just wanted to raise awareness of the importance of this interactive process. And I think we're going to start seeing it used a lot more as folks start to return to work. Right now, I think, broadly, as everyone has been home, there have been less employment discrimination complaints since the pandemic started. And, that seemed to be, very quickly as everyone was removed from the workplace. But as we start to come back to work, the questions around reasonable accommodation in the workplace are going to be front and center. And so, and I want you to know that throughout that process, DFEH will be here for you. We have resources to assist in that, and we want to continue to do ongoing public education because this issue is going to be front and center as we come back. But I want to, kind of talk about, with the backdrop of accommodation and FEHA and the numbers of disability-based discrimination in employment, talking about where a little bit of looking forward in light of the COVID-19 situation. Because even prior to COVID-19, many resources at the federal and state level, we're talking about there was substantial potential for job growth for persons with disabilities. That was prior to the pandemic. And, many people with disabilities have the educational attainment for the jobs that are needed today. And that's, again, why it goes back to this contrast of folks have the educational attainment, yet they're not getting the work. And, substantial job growth in occupations where for folks with disabilities or for people who have disabilities may be irrelevant as we move to the computer-based jobs. And most job growth will be in this type of technology where computer use will be important. And, the rapid development of new computer and information technologies, has particular benefits for many persons with disabilities to overcome physical or cognitive limitations and significantly increasing workplace productivity of people with disabilities. So there's a lot of hope. And I think as we look to the COVID, it's really pushed us through as the Secretary was talking about, as we have all embraced technology, new doors are opening. And in fact, yesterday, I was reviewing the New York Times, and Thomas Friedman, the columnist, had an article about kind of the future of work and talking about how things are changing because of the pandemic. And one of the quotes I took from the article yesterday I thought was helpful is he says this: as more work becomes modular, digitized, and disconnected from an office or factory, many more diverse groups of people, those living in rural areas, minorities, stay-at-home moms and dads, and those with disabilities will be able to compete for it from their homes. And I like this quote because it really was showing us that we are going to a new era with work. And we're already seeing it take place in yet just 6-7 months of the pandemic, that technology, working from home, flexible schedules is going to be widely embraced. And I know for many in the disability community, this was a struggle to get here, to have technology, to be able to have a flexible work schedule. The barriers that were there in order to work a 9-to-5, 5 days a week job, may be changing. And I think this is an era of, while it is a challenging and difficult time for all of us, folks have died, folks are sick, on and on. We could list out all how dramatic this has been. But if there's anything down the line we could look to for some hope, it's that will technology allow persons with disability to obtain those managerial jobs, to become more gainfully employed with all of this technology. And I think we're heading there, and we're seeing it, as I think the Thomas Friedman article, highlights. And, to kind of go back a little bit into COVID a little bit, the obligation to provide reasonable accommodations has not changed because we are working from home. Right. So even for folks who had a disability, who had accommodations in the workplace, if they're at home, they still may need accommodations. That's still a civil right that is protected. But I think, some of the issues we're going to be seeing with reasonable accommodation and disability, it's going to come back to this issue of, if someone has a disability that increases their risk for severe illness from COVID-19, is going to be the types of accommodations that will need to be ongoing until that risk is lowered. And I don't know when that'll happen, but I think this is why I talked about the issue of accommodation will become, turned up once everyone's going back to the office, right? Because then that question comes up of, I have a disability and I'm at risk of severe illness to COVID-19. I may need an accommodation so I can do my job and be safe. And that accommodation may be continued telework. It may be other types of accommodation. But the key with these accommodations, and I just want to let folks know in the disability community, is that even if you have a risk factor of having more of a severe illness from COVID-19, under our Fair Employment and Housing laws, you still have to have an underlying disability. Right, you still have to be disabled to get a reasonable accommodation. Right now, many of the severe risk factors relate to a disability. Right, so often they are parallel. Someone who has renal failure. Right, that's a serious risk factor to COVID-19. That would, likely be and would be a disability, and other types of issues. But just in terms of our guidance that we've put out, and I would tell everyone to check it out on our dfeh.ca.gov website. We have a COVID-19 section, and we have an employment FAQ that we have put together, or FAQs. And one of them is the subject around, having, quote unquote, the risk factor, and can I get a reasonable accommodation for that? And the answer is maybe, if you have a disability. And so I just want to, highlight that issue as we go back to the workplace, that we still have to have a disability to get the accommodation. And, I think as we look forward to getting back into the workplace, I still will say that we'll probably see disability complaints continue to be a ongoing highest level of complaint. And it's a little interesting this year, like I said, because no one's in the workplace. But as I've kind of foreshadowed the issues that are going to be arising, you can see that there's going to be a need for reasonable accommodation, let alone if there's, when a vaccine comes, et cetera. When is it safe to go to the workplace if you have a disability that is also could cause a severe risk illness to COVID-19? And myself, as a person with a disability, think about this, quite frequently. That, this is real deal for many of us. That it's not something to be taken lightly. That folks could become severely ill due to their disability from contracting COVID-19, and we all, I'm knocking on wood right now, but it's a real factor. So, I think we need to embrace reasonable accommodation as we start to go back to work. I think we all have to realize that the era of work it has changed, and thereby opportunities for persons with disabilities has increased for employment. And so I think we have a lot to look forward to in terms of what the future will be for employment, as the Thomas Friedman article highlights. So, I think in the end, there's a lot to be proud of. There's a lot to be excited about as we hit this 30-year milestone of the ADA. At the same time, we have to be vigilant because discrimination is ongoing. And, our department just in this last year has settled, several disability-based discrimination cases, and a lot of them, are kind of what you could kind of imagine, but some are a little bit different. One that I always kind of highlight is we've seen some employers with quote unquote fully healed policies, meaning if someone goes out of work due to a disability, the employer does not want them back in the office until they are in quote fully healed. And for a person with disabilities, that's a status that may not be attained. And so we were seeing folks being discriminated against with policies that were requiring a quote unquote fully healed. And of course, that's not the law, right? Folks are entitled to accommodations in order to do the job, but not in quote unquote a fully healed. So I highlight that as something still ongoing and a continued issue to watch for. We still see the just kind of flat out denial of reasonable accommodations occurring, that appear reasonable. One we did last year involved a woman with type 1 diabetes who requested a reasonable accommodation to be able to check her blood sugar more frequently. That was denied, causing her harm to her disability. So we still see these types of kind of baseline accommodations being denied. So I always want to lift up that we do need to educate employers. This is why this is important, but we also need to know we have DFEH here to help enforce these laws, to ensure that we hopefully not only just enforce law, but we can prevent discrimination. That one day, I always say maybe one day, hundreds of years from now, like in Star Trek, there won't be discrimination, right? We'll think of it as this long ago concept where we can't even imagine that this was happening, that we weren't hiring people with disabilities, we weren't embracing it. We're not there yet. We're not there yet, right? I hope we do get there. But right now, we have to remain vigilant. We have to continue to enforce our civil rights laws and look forward to the future, that the future of work has changed. It's happening right before our eyes. And this may be one of those, light at the end of the tunnel that may assist people with disabilities become more gainfully employed and get different job options than were there prior. So I appreciate being here today and the time, Bobby, and getting to connect with all of our stakeholders and partners. And with that, I know you have a great many speakers today and esteemed speakers. So I will cede any additional time. But again, I thank you for being here. It's always a pleasure. And I hope we can connect again soon as we talk about the upcoming issues as we start returning to work when this pandemic will finally go away. So I thank you for the opportunity to be here, everybody. Appreciate it.
Thank you, Branden. That was an excellent presentation. Really appreciate the analogy of the Star Trek, particularly.
My pleasure. Yeah, us Trekkies. All right. Thank you. Appreciate it, Bobby. Appreciate it. Thank you.
Branden, I know you're a busy person, but do you have a few moments to answer a few questions from our guests?
Yeah, absolutely.
Okay.
Hey, I will go ahead. Hi, Branden. I'm Susan. I'm the questions moderator.
Oh, hi, Susan.
And we have a couple of people that are typing in. Rami, our first question from Rami Chand is, do people typically file complaints after going through their department EEO process or in lieu of for DFEH? Yeah.
Well, yeah, no, good question. I see my colleague, Robin Blackwell from the Department of Fair Employment and Housing has been chiming in, which I greatly appreciate. I think, as Robin rightly points out, they can go right over to us. They can go do their internal process. It's really going to be on the comfortable level on what they feel. So it really depends. And I know everything always gets a little bit different at the state level, right? But here you can go right over to us if we can be of assistance. But oftentimes there's an internal mechanism that may provide more resolution more quickly. But yeah.
Hi, this is Rami. I'm the one who asked the initial question. Thank you, Branden, for answering, and Dana as well. And I noticed in the chat someone says that DFEH enforces the EEO. Could you speak a little bit more about that?
Well, what I would say to that is, and I think this is where we get a lot of, acronyms going, and it can get tricky. But the idea, is that the Department of Fair Employment and Housing is this, I don't say law enforcement body, but civil prosecutor that enforces all of our civil rights laws, which can be our employment, laws, the EEO type jurisdiction of anything under racial discrimination, sexual harassment, disability discrimination, etc. So many departments have an EEO department, but DFEH really encompasses the enforcement of those laws. So I see it, and I think even if you see behind my shoulder there, the EEO component is that, DFEH, we enforce all of that which goes into the EEO kind of acronym and concept of our equal opportunity laws. So racial discrimination, et cetera. We do all of that. So I don't see any difference there, except to say we enforce the laws. Internal EEO departments at agencies, enforce internal policy and discipline, and may do other things, harassment, do investigations. They definitely do some of our work, but we do it from the enforcement mechanism stage of our state civil rights laws. Yeah, EEOC is federal. They are our partners. Of course, here at the state level, we have greater protections under our state employment laws, which is always something to be proud of here in California. Federal law has some differences and caps on damages, et cetera. So we don't have that. But yeah, I see another question. Why do? Yeah, I memean, that's a deeper concept of the question of why do job employers ask about disability. I mean, I think we have some, guidance on this. I mean, I know now there's been a lot of folks asking about disability because they're trying to find out, and they're asking everyone, and it can't just be one, about the need for accommodations when people return to the workplace. And it's not, a requirement that people fill out, but have heard, a little bit more of this happening with the pandemic, is trying to find out what accommodations are going to be needed for people to go back to work. But of course, you're not able to use someone's disability status as a way to deny them a job, right? So this is always an area where, when we've seen studies done of where someone can discern whether someone has a disability from the resume, that the person with the disability doesn't get the call back, doesn't get the job. So always concerned where in the application process, or where someone is delving into a great many disability questions, but oftentimes it's part of the interactive process, which is true. When we request an accommodation, there will be this discussion, but generally there are some concerns, right? We shouldn't be trying to obtain information that's not related to these specific areas around disability, and special concern in the job hiring situation.
Branden,
but we could spend a lot of Susan. Yeah,
Branden, this is Susan again. Actually, I actually have a question about your wonderful statistics. So, as someone who is only been about 4 years in the state, I've been trying to look wherever I can. I work in IT. I'm a data person. Are your lovely statistics you talked about posted in some sort of report on your site, or is there a way we can get those numbers?
Yeah, absolutely. And Robin, help me out if you can on our website. Maybe we can just chat the annual report. But on our website, we just released, and I know it's like 2020 is ending, but we released our 2019 report last week. And I'll see here. Let me just see if I can chat it out to everyone right here. So you don't have to hide. But yeah, this just came out, and you can get all the data. It's very fascinating. I think it's especially, again, interesting because we have like the last 10 years of reports on there. Here we go. And yeah, to take a look back because I think, again, it's just, because I work from the side of, not only how can we enforce the laws, but how can we prevent it? So I run, our education outreach programs. And so this is something I'm always thinking about, of how can we get out in front of it so it doesn't happen? More training, more guidance, more of this work. But as you see in our annual report, it's an ongoing issue, and it's not just because there's a lot of complaints filed, it's because there's likely a lot of disability discrimination occurring. And then I don't know if I have time for this housing question. That's always my area of fun. Look, housing discrimination. What types of housing discrimination does DFEH face? I mean, it's all types, but broadly in terms of the disability context, it's usually a refusal to provide a reasonable accommodation or modification in the rental housing concept. I won't allow you to transfer to the first floor after a disabling situation. I won't give you the closer parking spot. I'm not going to allow the assistive animal. And I would say that there's a great many of those. But housing complaints, we had just under 1,000 last year. So when you look at employment, certainly higher. But in my experience, those are the types of cases. And of course, there are in the cases I've litigated, accessibility cases, right? Are folks blowing off the accessibility laws in housing for the actual built environment. So those are other types of cases we deal with. But yeah, but in the report, you can kind of get a full feel of everything, both housing and employment, that we work with each year. All right, well.
Branden, this is Bobby. I just have a couple of questions.
Oh, sure, okay.
One of which you alluded to you explained in great detail the interactive process, and Robin responded in our chat. It's a two-way communication. Is there a reasonable time frame within which the communication on both sides require a response? In other words, is it reasonable to say that we will resolve our reasonable accommodation case within 90 days or 21 days or any such number in the event the parties are interacting in good faith?
Well, I would say this. I mean, give a little bit of a lawyer answer, which is it's case by case, right? It really does depend on what is the accommodation and what perhaps research or information has to go into determine whether it can be done. Now, I will say it needs to be done promptly, right? It's not something that we'll get to at our annual meeting next year. No, I mean, it needs to be done promptly. So I wouldn't want to put a time frame, because some should be done fairly quickly, right? There shouldn't really be a 90-day window to decide something. Some may be more complicated and may require a little bit more of a back and forth and suggestions going across. Will this work? Will that work? Here's why we can't do A, B, and C. So I wouldn't want to say that there's a specific limitation on time, but where something does become an unreasonable delay, it is effectively a denial. So it's really one of those we have to kind of get a feel of the case and the facts. And like I said, it's something that should have been very easy and is taking an inordinate amount of time. That may effectively be a denial. But where the employer is responding, I mean, if there's no response at all, right, we have a denial, right? If we have a process of, hey, we got your request, we're looking at it, we're researching it, we're going to follow right up with some ideas, and then we're going back and forth. Now, that's different. We're engaging. But if someone says, we're not even going to respond, well, easy. In terms of once they have responded and they're kind of, if it's taking a long time dragging, it really depends case by case. But certainly, if it's an unreasonable, and again, case by case, it can be effectively a denial. But I don't have a specific time frame to provide.
Great. Thank you so much. My next follow-up question to that is what you alluded earlier about the underlying condition and COVID-19 and seeking reasonable accommodation.
Yeah.
You referenced diabetes as one, and that was unrelated matter where the person just wasn't allowed to do the testing, blood sugar testing. With context of COVID-19, if somebody's diabetic and they say, well, we don't want to come to work and we want to work from home because it our disability, which is the diabetes, puts us as a higher risk. Or let's say somebody who's immunocompromised on chemotherapy and they want to work from home because of that. Does that present an ideal situation to accommodate these individuals?
Well, it's a very good question, and I would really direct folks to our FAQ on this, and I'll kind of summarize it a little bit because these are there's guidance from CDC on this, and we've kind of incorporated it. And let me kind of try to paraphrase what the issue is. So the question really is, if an employee has a medical condition that increases their risk, for severe illness to COVID-19, is the employee entitled to reasonable accommodation, right? So according to the CDC, and I'm going to read from our FAQ on this because I think it's fairly succinct. People of any age, with the following underlying medical conditions are at increased risk for severe illness from COVID-19. So this is cancer, kidney disease, COPD, type 2 diabetes is included in this serious risk for severe illness. And so we say individuals with the following conditions. So those are the severe risk. And then we say the following conditions put you at increased risk, which, could be high blood pressure, could be HIV, could be a whole host that we list in including type 1 diabetes, which is interesting because I'm a type 1 diabetic, and that this is you're at increased risk, but you're not at the severe risk. But as we say, no matter what, whether you're at severe risk or increased risk, which we understand, that's a real issue. But if the underlying medical condition qualifies as a disability, then the employer must reasonably accommodate the employee, absent undue hardship to the employer. So again, it's like, yes, there may be these risk factors, type 2 diabetes. And so the question becomes, is this individual's type 2 diabetes, does it qualify as a disability? Does it qualify as a limitation to a major life activity under our definition of disability? Case by case. So what we're trying to say, and not trying to be cryptic with it, but in order to use our disability laws, one will have to be disabled. So these risk factors the underlying condition may be a disability, but if it's not, then you're not going to be able to get an accommodation. But of course, employers still may want to be flexible, and I think a lot are going to be flexible. But in terms of the hard and fast of the law, if I have a serious risk factor, many of those are disabilities. If I have cancer, right, that's a risk factor. That's going to be a limitation to a major life activity. So many of these will be, but I just don't think there was kind of carte blanche, like no matter what, if you have asthma, you're disabled and you get an accommodation. But that may be for many people, right? They may have a disabling asthma condition. So at the end of the day, it's going to be, still got to be disabled, but many of those risk factors are, the underlying condition is a disability, which would then allow someone to request that accommodation for teleworking, for example. Yeah.
Thank you, Branden. That was an outstanding and excellent presentation, very informative. I hope that it really helped our audience learn a great deal about what is it that you do and how your agency's been helpful in navigating these treacherous area of reasonable accommodation and overall disability-related matters. So thank you for spending the time with us. Hopefully you'll join us again in future, right?
Oh, my pleasure. My pleasure, yeah. Thank you again. I appreciate everyone. And thank you, Bobby, for having the Department of Fair Employment, Housing, and myself. Thank you so much.
Thank you, sir.
Thank you. Bye-bye. Take
Bye-bye.
care.